Johnny Ryan has testified in the US Congress telling this story, and he was a week ago in the European Parliament also explaining the story behind. Dear Johnny, the floor is yours.
Thank you, Pencho. So let me start off by saying thank you for having me again today after yesterday. I work for the Irish Council for Civil Liberties, but a few years ago, I had a role inside the online advertising industry, the tracking-based advertising industry. And in that role, I got an insight into how this system works. And the first thing that you need to get familiar with to understand this system is acronyms. So the first acronym of the day is real-time bidding, RTB. Now, I want to play, thank you for doing that. I want to play a hypothetical game with you today where we are all marketers and we're trying to sell something for a brand. So I'm showing you this chart here, and you'll see there's a bunch of acronyms in the chart. And here we have us, the marketer, with our money, and we're going to try to target some people. Now let's imagine, amazing. Let's imagine that we know maybe 10,000 of our customers, and we have data about them. We might have their email addresses. We store that data in a DMP, a data management platform. Now a DMP puts order on the data. Thank you, Pencho. It puts order on the data, and it will also very often say, okay, Johnny, you've got 10,000 email addresses of your customers. Would you like us to talk to some data brokers and find out where they live and what their disposable income is? And of course, I will say, yes, please. So now I've got really good data on these 10,000 people. And I'll also have data about people who are like them. Now we want over here to participate in auctions for people's attention so that we can decide which people we're going to show an ad to. For us to participate in those auctions, which happen billions of times a day, we clearly cannot be present ourselves. So what we're going to do is we're going to pay this company, a DSP, to be our agent at the auction. So the DSP is saying, Johnny, you want to sell these blue wristbands to hipsters. Whoops. You want to sell these blue wristbands to hipsters, and you've got 10,000 of these people. Will you tell us which 10,000 people they are and how much you're willing to spend on them? And so our DSP, our DMP, will give our agent information. Now the DMP is basically a Cambridge Analytica type of company, and the DSP is ready to participate in these auctions. Now along comes Pencho, and unsuspectingly he loads, think of any commercial website or app, pretty much anyone. When he loads it on his browser, for example, on his laptop, in milliseconds, the editorial content that he went to the page to view appears. But the rectangles, which will contain the ad, are still empty. And that's a problem, because we need to fill those rectangles with money to keep the lights on. So the publisher makes what's called an ad request to a supply-side platform. Now, poor Pencho, he's an innocent young man. He does not realize that he's being supplied to a demand, but he's being supplied. Now, the publisher, this is a euphemism, the publisher sends a lot of stuff, a lot of stuff, but let's just say cookies, to the SSP. And now we're ready to get on an auction. The supply-side platform, working on behalf of the publisher, packages up information about Pencho, who has just loaded this page, and says, okay, does anyone want to send this guy an ad? Now my clicker has died. Or, oh, whoops, I've broken a head there. Or okay, I'm going to jump ahead. So what has happened is the supply-side platform has sent a bid request, a request to companies who might want to show Pencho an ad. It has sent that to at least one auction, probably many. These are called ad exchanges. And each ad exchange sends that bid request on to tens or hundreds or thousands of DSPs. But remember, in our hypothetical company, we're looking for young gentlemen like Pencho who want to buy this amazing wristband. And so we say, that's the guy we were looking for, or he's very like him. So we bid more than anyone else, and our ad is put into that rectangle. Now, Pencho will notice this as he's loading a page, just for a little tiny moment, an ad will appear and it might even push the text down. This is all that has happened. And often there's an opportunity for the sneaky DMP here to perform what's called a sync, to learn about Pencho and update its profile about Pencho so that it knows him better next time. Now let's talk about incentives first. All of these cogs, the DMP, the DSP, the ad exchange, the SSP, they represent different bits of the market, the supply, the demand. They are distribution, but also they are very, very often owned by the same company. Even if it's not Google, very often owned by the same firm. So they're all kind of working together, right? It's not very clear where the money's going. Now I'm going to show you this system 3 more times, but much quicker, so that you definitely get it. Pencho wakes up in the morning, he visits the Daily Bugle. That was his first mistake. The Daily Bugle wants to figure out what ad to show him, and so it puts out a bid request to at least one ad exchange. Each ad exchange, in this case 4 of them, sends that bid request to 4 or 5 different DSPs, and one of them makes the winning bid for Pencho's attention, and its ad is put onto his browser. Now that's the promise, relevant advertising. The right person, the right time, the right ad, the right context, right everything. But the problem is, we have no idea where the data go. No idea whatsoever where the data go once the information about Pencho is being broadcast. And we can only imagine the kind of crazy stuff Pencho is reading in his private time. So let me give you an example, because this is not abstract. Let's take one DSP, Vectory. Tiny, tiny, tiny company. No one in the industry had ever heard of these people. They're so small, they had 3.5 million turnover in 2017. So they are tiny in the industry. When the CNIL, the French Data Protection Supervisory Authority, investigated Vectory in 2018, they found that these guys had hoovered up 67.7 million people's data just by sitting in on these auctions, just by being present. Now, if today, even today, I checked a week ago if this was live, if you go to Vectory's website, this is what you will be confronted with. Hard-coded in our DNA is privacy. Nonsense. This is the normal industry spiel. But if you scroll down the page, the claim is actually a little bit better than their competitors. They say, we only store 30%, and we dump everything after 12 months. But you can do the maths and ask the question, does that mean they actually had hoovered up 250 million people's data? Now, I say that to tease out the scale, because we're going to get to scale in a moment. Okay, 3rd time. You, brave people, decide to go onto the internet today. This is what happens when you land on a commercial website. Very similar to what happens when you land on an app. Get ready for it. You load the website, request the page, ad server kicks in, supply-side platform, at least one ad exchange, and then a broadcast of information to tens or hundreds of companies. And then a sync under the table, so the people know you better next time they want to sell your attention or bid on your attention. One of them sent the winning ad, bid, and it takes a whole lot of stuff for the ad to actually be shown. Now, none of this is necessarily a problem, unless the bid request is a problem. So what is in the bid request? That's the question. Now, we don't have to be brilliant investigators to know. We can know because these documents are open. There are 2 industry standards. Although there are hundreds upon hundreds of companies in this industry, there are only 2 parties that set the rules. Google operates its own system. It used to be called DoubleClick, but then they changed that to authorized buyers, which sounds much more legitimate. Then there's IAB, who aren't as good at the press, and their thing is called AdCom Specification 1. It's part of what's called OpenRTB. To confuse things, Google also uses OpenRTB. So these 2 documents are very, very similar. They're public. You could find them on your phone right now. Let's take a look at one of them. This is the IAB version, as I said, very similar to the Google version. Now, This is a 14,000 word document from which I shall spare you. But if you were an engineer, you would read this to know what you can and should put in those bid requests. It's a technical document. At the end of this document, they give what they call an abbreviated example, a summary example of what is in a bid request. Now, there can be, in the IAB system, 595 different types of data in a bid request. This is just a few of them. Many are benign, but this one gives an example of some of the problems. So I'm going to go through it with you and pick out some of the issues. The domain, the name of the website. Now, normally you would have the full URL, so let me remind you what a full URL is. Pencho has visited embarrassingwebsite.com/really embarrassing category /excruciatingly compromising article. That's a URL. Shame on you, Pencho. Now, we also have Pencho's ID. The identifier is what the ad tech company has called him. The buyer identifier is what our DSP has called him, because we're looking for that guy for the bracelet. Now we see that Pencho is a young lady, born in 1990, gender female, interesting. And we've got more stuff about his or her, I should say, device, IP address, mobile device identifier, and so on, and operating system version, and more stuff about the phone he's using, so that we could guess that we're seeing him again, even if we didn't have the IDs. But take a look at those IDs. They are far more specific than your social security number. Really long, unique strings. And finally, we have where this person is standing right now. Their GPS location. Now, Google's system doesn't give you the latitude and longitude. It gives you what are called hyperlocal coordinates. Make of that what you will. Now, this is not a complete list. Other things can be in there too. This system has recently been slightly reformed, but it is actually still in use. This is the context or content taxonomy, and it describes the content that the person is currently looking at. So if you are a victim of sexual abuse and you're reading material to help you with that situation, IAB says you can put in a code IAB 7-28 in the bid request broadcast that goes out to tens or hundreds of companies, along with your GPS coordinates. Google, slightly better, after a lot of pressure from me, has removed this particular part of its specification, but it still gives the full URL, which gives the game away anyway. Okay, so that's what's going on in the industry. What does the law say? Some people think the GDPR is complicated, some people think it isn't, but there's no dispute about the name of the law, right? General Data Protection Regulation. It's actually really simple. You're supposed to be able to protect the data. And Article 5.1f says, if you cannot protect the data, you're not supposed to have the data. It's a really simple idea. It's not even remotely complicated. Without security, nothing else is real. But let's look at what the industry has acknowledged in public documents. Okay, so here's about to be the industry view. This is a public document. You'll find it if you do a search for it on your phone right now, pubvendors.json. In it, it says thousands of companies get the data from showing a single ad, potentially. I don't think that would happen normally. You wouldn't be talking about thousands, but thousands is possible. Whoops. And there is no way to limit how the data are used once they are broadcast. Now that is a data free-for-all. It's a data breach, unquestionably. Now, this system was so terrible that even the IAB realized they needed to put out something new. So in August 2019, they came out with version 2, where they said, we may in the future adopt. Now they're talking about it more. An attempt to audit what thousands of companies have done with trillions of data about hundreds of millions of us. So this is not data protection either. And Google is no better. If we all wanted to, get involved for our bracelet company in Google's RTB system, we would have to say, okay, to a notification, to a message that says, we're not going to use RTB data, they call it call-out data, for any other reason. And if we plan to break the rules, we have to tell them before we do so. Now, this is a very romantic story. It's a picture of what happens when self-regulation walks into a bar and meets other self-regulation and has an inbred child. That is what you're looking at. Think the Deliverance soundtrack. So what is the scale of this disaster? And a disaster it surely is. Before we get to scale, I want to remind you of what you're looking at here and every time you use your device. You're looking at a MIRV. Think about nuclear weapons here. Multiple re-entry vehicles. A MIRV of a data breach. It's a data breach of data breaches. And I want to bring you to a single ad exchange to give you a sense of this mess. One single ad exchange. Now, we've litigation going in Hamburg at the moment because the enforcers haven't lifted a finger about this after 3 years, more than 3 years. In our litigation in Hamburg, we're going after the IAB, but we're also going after other parties too. One of them is this particular ad exchange. It's called Xandr. We're scrolling through 156 pages. This is a list of all of the third-party partners that Xandr's policies, public document, say they are entitled to send your bid request data to. The full count is 1,647 partners. Now, Xandr is just one of these jokers. Google is by far the biggest. This data breach is by far the biggest data breach of all time in a single day, and it's repeated daily. So let me bed that with you. Luckily, the industry has a solution. It's called the rectangle with rounded edges. It's incredibly effective. This has kept regulators at bay for more than a third of a decade. Behold the majesty of the OK or I accept button. The only honest consent message I've seen in the last little while is on Chris Hoofnagel's website. He's a professor of law at Berkeley. That's a good consent message. I understand what's happening here. I can get with it. Back in 2017, the IAB wrote to the European Commission, and it said, in the worst piece of lobbying ever, it said, please give us an exception under the e-privacy regulation, because they thought it might happen, to the GDPR, because consent is incompatible with our system of real-time bidding, because we've no idea where the data are going. And if we had any idea of where they first go, we've no idea what subsequently happens to them. Now that was March, I think, 2017, could have been April. The next year, to celebrate the arrival of the GDPR, the same organization, the same person, in fact, launched the Transparency and Consent Framework, which plagues you every day on all of your devices. Maybe not your watches, but it's everywhere else. It is a charade. This idea of using consent to a data breach is obviously ridiculous, and yet we're not seeing much happen. Now, something might happen quite soon, but it's taken quite a bit of work. Now, let's talk about consequences. Why does any of this matter? It matters. We know, you all know, that you're being tracked online. You did not need me to tell you. But we don't really see what the result of that is. Why are these companies tracking us? And if they're building profiles about us, what do those profiles look like? What's in those profiles? Well, now we know. Now we know because of this document. Our friends at the IAB celebrated the GDPR in May 2018 by introducing another technical standard, yet another illegal technical standard called the audience taxonomy. We're going to go through this document because this is the Rosetta Stone that lets data brokers trade what they know about you. There are about 2,000 different fields here, but I'm going to pick a few of my least favorite. We're going to spin through this document pretty quickly. So let's start off. A data broker that knows about your religion can tell another data broker that, if they've hoovered it up, for example, through RTB, by using one of the codes over to the left. Are you Buddhist, Christian, Hindu, and so on? Are you concerned about mental health, infertility, STDs, weight reduction, and now the taxonomy gets into the most intimate things. Does your child have special needs? It's not just you who's being profiled, it's your children. So if you have a child with special needs, IAB says the code for data brokers to know that and pass it on efficiently is 357. This is how they celebrated the GDPR, same month. And these people, by the way, are currently still lobbying everyone here probably with a straight face. What are your political views? Are you conservative, green, independent, liberal? Note, by the way, note what's on the screen. This is the fate of our democratic system here, and this is the level of thoughtfulness that goes into this thing. Now, you may have seen this story. It came out a week ago in the Wall Street Journal. It's a good story. It says there are two data brokers, Mobile Walla and Uber Media, not related to Uber. And what they were doing is they were using RTB data and other data to get people's location and profile them. And that data about all of us that leaked out from the RTB system, which has no technical control at all, by its own admission, ended up in the hands of these data brokers, and then it was passed or sold to the Department of Homeland Security and to other to parts of the US military, and it was used for warrantless surveillance. Now, we told the Irish Data Protection Commission about those data brokers 14 months ago, and we copied our Minister for Justice on that letter. Exactly these brokers. In that same batch of new evidence, we also told them about another company, and this one is European and has received European Commission funding. It's owned by Cloud Technologies based in Poland. It's called OnAudience. You won't find this online now. These segments are no longer online because this was a big media story and it embarrassed them, rightly. I clicked on Ireland, and then I went and I tried to find out which segments, which people could I buy. And it turns out I could buy people who had chronic pain, which is from the audience taxonomy. And you remember our incest and abuse support, I could get people there too. And I could reach those people through, let's call them out here, 200 people from their trade desk, TTD, their trade desk. Google's got a bunch of other stuff it's in trouble for too. 2,300 people for chronic pain. Right now, this is where we are. We have the biggest data breach of all time, leaking what we're all watching, reading, and listening to, and where we are. And we're allowing a system that allows that data to be vented into a data broker system. And the net effect is that everyone you've ever met, everyone you will ever know, almost certainly has been exposed to this system. But this is not just a data protection problem. It's a market problem too. And it's an information and society problem. I want to move this conversation to the market and the effect of data leakage. And let's start off where I like to start things sometimes by looking at a big company's privacy policy, because we all love to read privacy policies. This is Google's privacy in terms. If you zoom in to the maximum amount, this is how big the small text gets. But even still, it's not entirely clear what this paragraph means. So let me clarify it by moving the text in the middle that is part of this sentence out of the way. You ready? Here we go. You get it? So when I was working for a newspaper and we had Google plugged in our system, we were leaking our audience data to that competitor who could then use those data on their own properties at a much higher margin. Now, this issue of leakage of audience data in the real-time bidding system It goes far beyond Google. Let's pick on Pencho again. Pencho visits again the Daily Bugle. No, we'll call it John. John visits the Daily Bugle. John reads about business, politics, and then starts to look at reviews of really expensive electric saloon cars. The bid request goes out and it says this person is an auto intender, a person who wants to buy a car. Everyone wants to reach auto intenders. They're the most valuable audience on the internet. So all of these parties who receive the bid request are thinking, auto intender. I'm waiting for this slide to update. We might have a problem here. Is that okay? Is that showing? Oh, okay. Yeah, okay. So everyone in the middle is seeing that John is an auto intender. Now, in the short term, the Daily Bugle gets a payout. An ad is shown. But later on, John visits destroytrust.com or bikinibabes.com or crappywebsite.eu, whatever. And they send out a bid request. And all of these parties in the middle realize that expensive Daily Bugle reader, who's really pricey for us to reach in the Daily Bugle, we can get that guy again at a massive discount by going to destroytrust.com. Now, what happens here is that the Daily Bugle is no longer able to charge for John tomorrow what it was able to charge today, because I can buy John really cheaply over here. But the second thing that is happening is that these people are the ones who can now give the brand, the advertiser, the discount. But the advertiser doesn't know what the difference in price is. So they can take an enormous percentage, and it's all built as a parasite on legitimate media's business. It allows websites that otherwise would not have a business model to exist and to profit by arbitraging on legitimate media. Now, how much do the tech firms, who are IAB's members, how much do they take from publishers? The answer is, we have no idea, but the estimates are terrifying. So let me pick the biggest one, because I don't like them. Let's give out about this industry. The Guardian ran a sting operation in 2016. It masqueraded, it pretended to be an advertiser, and it bought ads through this system with all of the bells and whistles switched on. It bought ads on its own properties, on the Guardian's websites. For every pound sterling that the Guardian spent as an advertiser, it received 30p as the publisher. 70p had disappeared into the tech industry. Now that's bad, but what is much worse is if John is not a human being. What if John is a bot operating on a smartphone in a warehouse with thousands of smartphones? So a criminal enterprise tells a bot, go visit legitimate publisher, build up behavior as though you're an expensive auto intender. The ad gets shown, but these people are all now trying to retarget and track this bot. They don't particularly care that it's not a human, but they may not be able to tell. Now, the criminal website says, great, you've done a good job. Now, bot, come home and bring those advertising euro with you. Now, this is how you divert billions of euro from legitimate media out of the hands of advertisers and away from the newsrooms that keep the system honest. And again, our estimates on this are absurdly different. Now, some of these things are measuring different types of fraud or in different markets. So there's a good reason why they're very varied, but the best reason they're varied is that no one has a clue. We know it's billions. The question is it double, single, or triple digits? It's not really clear. So back to our earlier diagram. This is what I showed you at the beginning, but if we spin it so that it looks like a market, the buyer, the advertiser, is subject to massive fraud. The distributor is taking a huge invisible tax and allowing a business model for the bottom of the web, which, okay, it can exist, but should it have a business model that eats as a cancer on legitimate media? And legitimate media is allowing its audience to become a commodity and to be arbitraged. Now, if you strip out the personal data from these bid requests, which is a simple solution in my view, a lot of these problems go away. And this is the same discussion we have had in many other industries. How happy are we to have dirty technology? And don't we want clean technology? We have the same issue in the automotive sector. 100 years ago, more than 100 years ago, the petrochemical engine won. It won in the contest between the electric engine. That did happen. And if we could, we would drive these things until the world burns, right? But luckily, the technocrats among us have told us you're not allowed to do that. The negative externalities are too massive, and we've now decided to start measuring them. That was the important thing. So we're going to start incentivizing this thing. That's what happened in the automotive sector. But if you've got a Ford Mustang, 1976, blah, 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 that's unusual. You're allowed to have it, special dispensation. The same is what data protection law basically says. And if it were enforced, this would be the same thing. If you can keep the data safe and run an ad system off it, maybe there's a way to do that, right? Let's talk about it. But if you're going to have a data free-for-all, you got to not have personal data involved. Now, the industry is aware that a change is coming. There's so much pressure. And so in July this year, the IAB again produced this report. And in this report, their own figures say 81% of consumers prefer content that is targeted by context of the material. And they say the market for this in 2025 is going to be, and they say in dollars, $412 billion. So the future looks bright if we do this correctly. But let me conclude, and I'm a little bit over time here, of course, with the problem. It's not just that this stuff is happening. It's that it's been allowed to continue. That's the problem. And it's an enforcement problem. As I said yesterday, we have the tools, but we are not using them. Let me give you a brief chronology of my complaint to the Irish Data Protection Commission, which has been duplicated across the EU in, I think, every jurisdiction now, to other enforcers too. I had blown the whistle previously, privately, but finally on the 12th of September 2018, I filed the complaint. Now, the DPC spent 8 months and 11 days doing something, I don't know what they did, but they launched an inquiry after 8 months and 11 days. Clearly, they did not share my sense of urgency, that the next election might be played with, used as a plaything by people who had recourse to that data broker data. Now, we had correspondence. We have a lot of correspondence with the Irish DPC, trying to get them to take action. And the last bit of correspondence before I testified on this in Dublin, I found that by the 19th of March, in a letter from them, it turns out they had not yet, even at that stage, written for themselves a statement of issues. A statement of issues is a very brief document where the enforcer sets out what they plan to investigate. Now, that's 2 years, 6 months, and 8 days after being told about the biggest data breach of all time, which has a bearing on health data, political data, yada, yada, yada. And the latest update is nothing. So time to completion at last count is infinity. Maybe a statistician might quibble over that, but I'm not sure. Now, this isn't some small complaint. This has been on the front page of the FT not once, but twice. Right? This is not a thing that's going to go away. And in the time since they've got the complaint, it's got worse. So I'm showing you here just 3 of the exchanges for which I could get data over time. This data breach has grown since the enforcer has been told about it. So let me conclude, Pencho, I know I'm over time, with a question for Karolina, if she's still here. Hopefully she is. She was great earlier, but I'd like an answer to this question. When does the European Commission step in? When is it acknowledged that this is a crisis? This is a crisis. Is this not a crisis in the Commission's view? What is the criteria that the Commission uses to decide whether to launch an infringement procedure? If this is not the time, when is the time? If the stakes here are not high enough, have I left something out? I cannot imagine a reason to not act now in a hurry. So let me summarize with 4 points. First, real-time bidding, which you have now been told about in exhaustive detail with lots of arrows, is the biggest data breach of all time, and it is repeated daily. Second, this thing, is what feeds the system of disinformation. It is a cancer eating at the heart of legitimate media. It allows voters to be profiled, and it allows them to be micro-targeted. It's the trifecta of a breakdown of the communications that allow society to function. Third point, for some reason, those who are in a position of responsibility to fix this problem, the supervisory authorities, the states, and the Commission above them, feel no urgency whatsoever about this problem. I do not understand that. And let me just conclude by saying there is an industry waiting for its moment here. There are fantastic companies that can do this safely. There are Teslas all around us waiting for old Detroit to be told you are not allowed to pollute any longer. Thank you very much.
I have not enough listening to Johnny a couple of times, and I'm sure that I'm going to see it many times also after this event. I hope that Karolina had enough patience and is still with us. She's smiling, and that's good.
Oh, good.
It matters to us. Karolina, actually, I had a question for you, but actually, I hope that you have listened to the question of Johnny. Do we have...
Very carefully, of course.
Yeah, do we have an enforcement gap, and why that?
Well, just the first thing here. Press release from the Belgian Data Protection Authority. Belgian DPA sent its draft decision in the AIB Europe case to the European counterparts. The case concerns precisely the Targeting Interactive Advertising Bureau Europe, AIB Europe. So all the practices which were addressed now by Johnny and on which he so eloquently and elaborated, it was very impressive, are being now, were investigated and are subject to a decision from the Belgian Data Protection Authority as the competent one. And they are submitted to the counterparts, European counterparts, in beginning of the last week. And they will be subject to Article 60 GDPR procedure, and we will have a decision hopefully very soon. So this is the first thing. This is as much as there is to say about lack of enforcement, about Commission pushing individual independent data protection authorities to take up a certain case and to deal with a certain undertakings. It's a frontal attack on the independence of the data protection authorities. And I think a mere glance on the conditions of the independence, even if not anchored, so even if we do not want to look at the GDPR, but at least at the case law of the Court of Justice, will convince everybody that it's just completely impossible to do that. Now, this is also not particularly fruitful to copy in Ministry of Justice or whatsoever when one pleads for a data protection authority to take up the case. Should it be possible for any kind of ministry, for the state to influence the data protection authority to take up or not a certain case, then we have a case of a breach of independence of the data protection authority. I think we have to make up here our mind a little bit. What do we want? Yeah. So first of all, as far as the real-time bidding is concerned, the issue was investigated and is tackled at the appropriate level, but appropriate data protection authority is tabled to the within the cooperation mechanism, and the decision is about to fall. Now, this decision, since it affects the practices agreed by several undertakings as far as the real-time bidding and the cookie setting practices are concerned, will affect not only one undertaking, but all those who participate in such practices. I think it's much more effective. So much this is the comment.
Johnny would like to reply.
Yes, I'm glad you've taken note of the Belgian draft decision, but I must correct you, Karolina. The Belgian draft decision relates only to IAB Europe, which is a controller only for it's called a TC string. It's data that is created for the consent system. So the controllers for the RTB, in addition to the various companies involved, would be IAB Tech Lab, which is based in New York, and Google, which is, of course, headquartered in Dublin. So we haven't seen actually any action on real-time bidding. The Belgian case, and I've been the lead complainant on it for quite a while now, the Belgian case is trying to deal with the consent spam. It's a problem that is very closely related to RTB, you're right, but it's a slightly different problem. It doesn't get to the whole. But it is welcome, and it is good to see that the APD has made progress there. On the question of independence, the states have a role. Data protection is an objective of the Union, as we all know, and the states have an Article 4 responsibility to see that data protection is upheld. Now that's a broad general thing, but it is real. And although the supervisory authorities are independent, and they must be, I think, for example, in the Irish case, the state has two things that it can do. The first is, in the Irish Data Protection Act of 2018, the minister is the one who can decide, the Minister for Justice, whether to appoint additional commissioners. So there could be a college of 3, for example, and the minister can decide which among them shall lead. Now that is quite a lot of power to have, and she does have that at her disposal. The second issue is whether, and I think it's essential, the Irish Data Protection Commission now should have an independent review of how it can be strengthened and reformed as a general exercise. And I know that the Commissioner is sympathetic to that. So we're not talking about in any way minimizing or degrading what should be independence. But the states have a role. They have a responsibility, as does the Commission.
Well, if I may. Thank you very much. Thank you very much, Johnny. Concerning the content of the decision, I didn't see it. The Commission will be able, as a member of the European Data Protection Board, see the content of the decision only should it reach Article 65, so the consistency mechanism. From what I understand, and you are much more knowledgeable about the RTB protocols or not, precisely the open RTB protocol will be is what is investigated here, and even if it's not covering the whole practices, a big chunk of it is covered by the decision. So to the thing, we cannot speak about a complete failure and these big words. There is no enforcement in Europe and so on and so on. And I think the facts speak for themselves. Now, concerning the situation in particular in Ireland, I would think that the system, we are here in the area of fundamental rights. The system of enforcement of these fundamental rights is provided for in the light of the Charter, which requires independent data protection authorities, is set up in the GDPR in such a way so that these authorities are truly independent. One. Now, the responsibility of the state is to preserve this independence. Who is and how is pre-selecting the candidates, and according to which national rules the candidates are pre-selected, as long as there is a transparent procedure which is set up in accordance with the GDPR. I'm just looking for the article. The Article 53. And the members and the DPAs are appointed by the means of the transparent procedure by the Parliament, government, head of state, or independent body entrusted with the appointment under the member state law. there is this rests with the discretion of the member states. So how the candidates for the position are pre-selected, how many candidates they are, how the data protection authority is organized. This is not, as long as it complies with the conditions of Article 53, this is not something the Commission should say that much about. And having said that, even if the Commission, as the guardian of the treaties and a body which, an institution, not a body, sorry, which ensures or monitors a correct application of the EU law in the member states, we step in when we see that the situation is not being addressed at the national level. Now, the situation in Ireland is completely different. We have the report from the Cross-Party Justice Committee of the Irish Parliament and Senate, which made 17 recommendations addressing some very interesting issues. And we find that a very positive and appropriate steps are being taken at the national level to discuss how to address possible questions of the GDPR implementation. And indeed, from the position of the Commission, it's the first place for the member states to ensure the application of the EU legislation. And if the actions, should there be any problem, if the actions taken on the national level are insufficient, the Commission's intervention could be necessary. So, yeah, this would be my reply to.
Okay.
Maybe just a short follow-up. Have you considered in the last 2-3 years starting of any infringement procedure concerning GDPR against any member states? Could you tell us?
Of course, we have several.
Okay.
We have several infringement proceedings, and we just started one against Belgium concerning the independence of the Data Protection Authority. We had proceedings against other member states, and I wouldn't like to name and shame here. But
okay.
Yes, it's clear, yes, we did.
Okay, Giorgione, just short remark because we have to close the session and we are over time.
So two important clarifications. The cross-party report from the Irish Oireachtas is not from the government. They are beseeching the government to take action. So this is not and should not be interpreted as action taken. This is a list of requests that concerned parliamentarians in Ireland are making, not evidence of action. Quite the contrary. Second, I want to make sure it's clearly understood by the Commission that Belgian procedure, and we were heavily involved in it and know what happened, it is focusing purely on the consent system. The personal data involved are purely the data in the consent string. Now, part of that I dealt with in my presentation. We do not get into the underlying data breach except to say that because that data breach can't be fixed, the processing of the consent string infringes data minimization. It doesn't, for example, the Belgian action does not touch even slightly on Google. Right? Google's authorized buyers is not addressed. And hopefully it might make an impact on OpenRTB, but we have to wait and see.
Well, I think very much, because as I said, I didn't see the content of the decision. I don't know exactly what is addressed in there, but establishing the lack of existence of a valid legal basis for the processing is a precondition in order to be able to speak at all about the data breach. And as I understood your presentation, precisely this lack of a valid consent, in your understanding, is the reason we can speak about the data breach.
No, we can speak about a data breach because of a lack of security. So security was the sin from which all of this flowed. It was then impossible to get a lawful basis or to have transparency, accountability, or anything else.
But we are offering more space for discussion. in the coming months, years, and I hope that, Karolina, I hope that at least some arguments also help you in your daily work. I hope this discussion was useful, and we really appreciate your time. Dear Johnny, it was a pleasure listening to you.
Thank you, Karolina. Thank you, Pencho.
Thank you very much.